welcome everyone. We're going to wait just about 30 seconds for folks to get on the webinar and then we'll begin.
Mute cell phones.
All right, I think we'll get started. Welcome. We're thrilled to have you all join us today. My name is Julie Kobik, and I'm a board member at the Rappaport Center for Law and Public Policy at Boston College Law School. The Rappaport Center brings people together for conversations on important topics at the intersection of law and public policy. Today's topic is about how our Constitution's federalist structure, with its division of power between the federal government and the state governments, has stood up to or not stood up to the COVID-19 pandemic. We have a tremendous panel for you to hear from today. But before I turn it over to Dan Kanstroom to introduce the panel, I'd just like to say a few words about Dan, who's going to be the moderator. So Dan is the faculty director of the Rappaport Center and also a professor of law and a distinguished scholar at Boston College Law School. He's also the director of the International Human Rights Program. He's an expert in constitutional law, administrative law, immigration law, and human rights law. He's written several books, published hundreds of pieces in journals and newspapers and other publications, and his teaching has inspired generations of law students. So Dan, thanks for kicking off our panel.
Thank you so much, Julie. I'm still stuck on that generations thing, but that was a very kind introduction. Thank you. And thank you especially for helping us to conceive and to organize and to implement this panel. If I may say, you're an excellent role model for our other board members, and it's much appreciated. I also want to thank our incredible executive director, Lissy Medvedal, and our fantastic assistant, Cindy Wynn, for excellent and absolutely indispensable work. So as faculty director of the Rappaport Center at Boston College Law School, it's my great pleasure to welcome you all to today's presentation about COVID-19 and federalism, opportunities and challenges. As of course we all know, we're still in the midst of a deadly, massive, insidious, and indeed I would say invidious pandemic, at least a 100-year pandemic that has affected every aspect of life everywhere on this planet. We struggle to grasp the magnitude and the meaning of such an event, let alone to understand the many questions it raises about law, society, and politics. We've chosen a rather specific way to approach this subject today, as Julie mentioned, that of the political legal doctrine of federalism. Well, what do we mean by that? Well, in its most general sense, of course, it was succinctly and well described recently by two prominent social scientists as, quote, an arrangement in which two or more self-governing communities share the same political space. So basically what we hope to explore today are the responses to COVID-19 that we've seen so far from the federal government and from states and localities. And we're also going to think hard about the long-term implications of those responses. But of course, federalism also has quite specific historical, political, and legal doctrinal implications. The Federalist Society, for example, was said by the Washington Post in 2019 to have reached, quote, an unprecedented peak of power and influence, unquote. 5 current Supreme Court justices, Kavanaugh, Gorsuch, Thomas, Roberts, and Alito, are current or former members of the organization. And its main principles are said to include, quote, checking federal power, protecting individual liberty, and interpreting the Constitution according to its original meaning. But federalism, like all other constitutional principles, has evolved and continues to evolve. Nearly 2 centuries after James Madison first began talking about it in Federalist 39, we know, as every law student knows, or I would say should know, we have our federalism as pronounced in Munger versus Harris in 1971 that was said to represent a system in which there is, quote, sensitivity to the legitimate interests of both state and national governments. These words, sensitivity, legitimate, mask deep, persistent, and in some ways doctrinally insurmountable complexities. And we've seen this today in response to the pandemic. In a 2012 article entitled Our Federal Isms, plural, derived from a lecture, Yale Law Dean Heather Gerken noted that, quote, federalism scholars typically divide into camps. Some favor state sovereignty, others favor state autonomy. Some insist that states require formal, judicially enforceable protections against federal intrusion. Others favor informal protections through the political process. Some favor something called cooperative federalism, and others even question whether cooperative federalism really is federalism. But she said, in the legislative and administrative arenas, our choices are varied. We need not hew exclusively to one vision of federalism. We can choose all of them at once, and we do. But this too raises very difficult questions of both theoretical and practical significance. How should we draw the lines between these spheres of power and implementation? From Jefferson and Madison versus Adams and Hamilton, from John C. Calhoun versus Andrew Jackson and Abe Lincoln, from Orville Faubus and George Wallace versus the Kennedy brothers and Nick Katzenbach, from Ronald Reagan's so-called devolution revolution and the new federalism of the 20th century to today's CDC guidelines, red state versus blue state COVID policies, face mask suggestions and rules, executive closing of border by governors, etc., we see an incredibly rich and complex conversation, which deploys the language of federalism in very different modes. In fact, some have argued that federalism has failed us profoundly in this moment. But in a recent op-ed, Professor Larry Tribe, not normally well known as a federalist, wrote that, quote, to misconstrue this moment as the death knell of federalism dangerously misunderstands how the pandemic has showcased federalism's versatility, resilience, and strength. As these endless months have stretched on, he continued, American federalism has flexed its institutional muscles, not in a hapless rendering of Trump's ego projects, but squarely in the common defense, end quote. So in sum, our subjects for today are complex and profoundly important. Our panelists will consider how has the pandemic influenced thinking about federalism? What challenges and what opportunities seem most salient regarding the principles and applications of federalism? And what should states and localities do? What may they not do, etc. For this, we have a truly outstanding panel of experts with deep experience and knowledge in federalism in general and in many relevant applications. Given time constraints, I'm only going to use brief bios, but please know that these are three incredibly accomplished people about whom one could surely say much, much more, all of it positive and, to my mind, reverential. In the order that they're going to present at the outset, let me start with Michele Mello. She is a professor of law at Stanford Law School and professor of medicine in the Center for Health Policy, Primary Care, and Outcomes Research in the Department of Medicine at Stanford University School of Medicine. She conducts empirical research into issues at the intersection of law, ethics, and health policy. She's the author of more than 200 articles and book chapters on medical liability, public health law, pharmaceuticals and vaccines, biomedical research ethics and governance, health information privacy, and other topics. She is the recipient of a number of awards for her research, including being elected to the National Academy of Medicine at the age of 40. She was also previously a professor at the Harvard School of Public Health. She now teaches courses in torts and public health law. She holds a JD from the Yale Law School, a PhD in health policy and administration from the University of North Carolina at Chapel Hill, an MPhil from Oxford University, where she was a Marshall Scholar, and a BA from Stanford University. Our second speaker is Bessie Dewar, who is the state solicitor, a relatively new position, in the Office of the Massachusetts Attorney General. She leads appellate advocacy on behalf of the Commonwealth. Before joining that office, she litigated appellate and commercial matters at Ropes & Gray, LLP, and civil rights cases at the Public Interest Law Center of Philadelphia. She was a law clerk for Stephen Breyer at the U.S. Supreme Court, and before that for the Honorable William A. Fletcher of the U.S. Court of Appeals for the Ninth Circuit, and the late Louis A. Pollock of the U.S. District Court for the Eastern District of Philadelphia. She's a graduate of Yale Law School, the University of Cambridge, and Harvard College. Finally, we have Donald Verrilli, who is currently a partner at the law firm of Munger, Tullis, and Olson. Immediately prior to joining the firm, Mr. Verrilli was the Solicitor General of the United States. appointed by President Obama, where he served from June 2013 to June 2016. During that time, he argued 37 cases before the Supreme Court. Before becoming Solicitor General, he served as Associate Deputy Attorney General and as Deputy Counsel to the President. He's a graduate of Columbia Law School and a Yale undergrad. He clerked for Judge J. Skelly Wright in the DC Circuit Court of Appeals and then for Associate Justice William Brennan at the Supreme Court. So our format will be this. First, each panelist will give introductory remarks in response to a general question that I will pose, and they'll speak for about 4 to 5 minutes each. Then we'll have a second round of questions from me, followed by opportunities for the panelists, and I hope we can do this, to respond to each other's responses. If we have sufficient time, we may then repeat that process, but we are definitely going to reserve at least 30 minutes for Q&A. Now to do this, you need to know a couple of things. First of all, we are recording. Second of all, panelists can neither see nor hear anyone at first. So Q&A will be via the Q&A feature. You may also use the raised hand function. You may also chat, but if you chat, your chat will be public. I think I got that right. I hope I got that right. All I can say is welcome to the New World Order. Here we sit. Let's begin with our first round question for Michele. Michele, to get us started, I wonder if you could discuss how federalism has affected the structure of public health law in the United States, particularly laws and executive actions relating to fighting infectious disease.
Sure. Our constitutional structure rests primary responsibility for public health with the states. Of course, under the 10th Amendment, all powers that are not expressly given to the national government are reserved to the states. And among those, courts have made clear, is the police power. States' plenary power to enact laws of every description that promote the public health, safety, welfare, and morals. A very broad power that is limited by separation of powers doctrine, by independent constitutional rights, civil rights, and civil liberties, but affords states broad latitude to address threats to public health. The federal government's ordinary public health legal authority is more limited. As with any exercise of federal power, it has to identify a jurisdictional hook in the Constitution, such as alleging that a health threat affects interstate commerce or threatens national security. It can also flex its spending and taxing power to address public health problems. So these are the everyday public health powers that the states and federal government have. In times of emergency, by dint of a number of different statutes at the federal and state level, both units of government can claim for themselves extra special powers that are reserved for use during declared emergencies. There are a broad range of statutes addressing emergency powers in different areas, such as the need for provisioning, stockpiling, and distributing resources during emergencies, and the need to be able to exercise special coercive powers, for example, quarantine and limits on interstate travel. There are some particular aspects of those emergency powers that are really salient for our current moment. One is that they are time limited. They can only be exercised for a period of usually 30 to 90 days before a legislative body has to get involved as a check and balance. The second is that they can be delegated both vertically and horizontally in most cases. And the third, again, is that they tend to be addressed to particular kinds of areas. So we have a very complex but very fulsome structure of constitutional and statutory powers that are divided among the units of government. And the primary concern, particularly regarding the emergency legal framework, has long been that the national powers might be exercised too coercively, that authorities might arrogate too much power to themselves, responding to public pressure's demand to do something, and that there would be inadequate checks and balances. That's another reason why a lot of even the emergency powers are reserved to the states. The interesting thing about COVID-19 is that in this case, we have seen the opposite of everyone's expectations and the opposite of everything that we've seen in prior epidemics, which is the federal government sitting back, doing very little, doing what it has done very late, very inconsistently. And suffice it to say that that situation has caused many public health experts to ask whether the situation that we now find ourselves in reveals something structurally wrong in our system of public health law, or is just another case of misuse of structures by an inept administration.
Thank you. I realize you have to mute, I have to unmute. There's always a lag here. I apologize for that. You know, one thought that occurred to me, maybe we'll be able to come back to it. This is in my, as Julie said, I also teach international human rights law. And it is interesting that international law actually has quite specific structures that limit emergency power declarations. Article 4 of the ICCPR is about derogations. But in the US context, we have a sort of amorphous set of principles about how far a governor may go when declaring an emergency and so forth. So it's just a thought that maybe we'll come back to as we go forward. Okay, Bessie, let's turn to you. Please unmute, and I will mute after I pose my question. At the beginning, particularly from your perspective as a part of a state government, a legal actor in a state government with considerable authority, do you think that the COVID-19 crisis has revealed particular weaknesses in our federal system at this point?
First of all, good afternoon, everyone, and thank you, Dan and Julie and the Rappaport Center for organizing today's event and for your kind introduction. From my vantage point, at least, it seems as though, above all, the COVID crisis has put into stark relief for people across the country the fact of our federalist system and both its advantages and disadvantages. For example, while there have been urgent calls for a stronger, coordinated response from the federal government, given the evident limitations of the patchwork response from the states, it's only because the states have independent and indeed primary authority, as Michele was saying, to protect the health and welfare of their residents that some states have been able to take active measures to tamp down the epidemic in some states. And because of our federalist system, the President of the United States was prevented from lifting crucial measures like stay-at-home orders that are uniquely within the powers of the states to impose. But of course, not all states have had the same leadership nor the same resources to fight the epidemic. And while the resource problem could theoretically be addressed by our federal government, weaknesses in state leadership cannot. So to me, the most obvious lesson here is that our governments, both state and federal, are only as effective as the leaders we elect and the officials they appoint. And this is actually one of the reasons that our federal structure of divided powers continues to be to our advantage as a republic.
Thank you very much. Don, let's turn to the more general level. I wonder if you could speak for a few minutes about how you think one should approach questions about the exercise of federal power and of federalism limits on that power, particularly, but maybe not exclusively in the COVID-19 context, as a kind of framing discussion for what's going to follow.
Thanks, Dan. Thank you for your gracious introduction. And I want to join Michele and Bessie in expressing my gratitude to the Rappaport Center for putting this great program together, and to all of you who are giving up some of your time to participate in it. Thank you. So striking to me, thinking about this, and of course, thinking about it principally as somebody who spent the better part of 8 years in the executive branch of the federal government, dealing with issues of the proper scope and limits on federal power. The context that we're dealing with here is new, and it poses some particular challenges, some unprecedented really, and our other panelists have described them extremely effectively. But the question at the end of the day about the balance between federal and state power that we're wrestling with here, it's the same question that we've been wrestling with as a nation since Hamilton and Jefferson were fighting about whether Congress had the authority to establish the first bank of the United States. And I think you referred to that, Dan, in your introduction. So I thought maybe to frame the discussion, I could offer two perspectives. And the first is informed more by my experience as a lawyer in the executive branch, The second is formed more by my experience now as a citizen watching the executive branch. The first perspective, in one sense, we're clearly dealing now with an interstate problem that calls for national collective action. To state the obvious, the virus doesn't respect state boundaries. States get thrown into crisis because the virus is brought across their borders from elsewhere. It infects the population, spreads within the state, and then that population in turn becomes a threat to the well-being of other states as the virus gets exported. And, we want the needed supplies, the vitally needed supplies, PPE and testing and treatments to be allocated efficiently among the states when and where they're most needed, and flexibly as the virus waxes and wanes, surges and wanes in different parts of the country. And, it's crazy to experience what we did a couple of months ago with states being forced to bid against each other and against the federal government to obtain essential supplies. And, at some level, only the federal government can really bring to bear the economic resources that are needed to finance the crash program to identify vaccines and cures. No one state could bear those kinds of costs. And even if it did, it would be extremely unfair to have that one state bear those costs and then have all the other states free ride on that one state's effort. So really, if you think about it, this is a textbook case of spillover effects and collective action problems that should justify a robust exercise of federal power to deal with a problem that's not just national in scope, but truly interstate in the ways I've been describing. In some ways, it's the whole reason why we have a federal government under the Constitution rather than the kind of government we had under the Articles of Confederation. And what we've seen really, from my point of view at least, is failure on the part of the federal government to exercise that power. And as a result, what we have is a national embarrassment. It's an abysmal failure in dealing with the virus as compared to other nations, and it's inflicted staggering harm on the country. So as somebody who believes in the good that the robust exercise of federal power can do, and who has seen the good it can do, in healthcare in particular, it's been incredibly frustrating to watch. But here's the other perspective, and Bessie alluded to it already, or identified it already. Everything I've said so far presumes that the federal government is going to act for the good. And it's going to act in the interests of the American people and exercise the kind of authority to deal with interstate problems that I just described in a way that would forcefully and effectively deal with the virus. But what if those in control of the federal government have a different view? What if they think that the states that have moved aggressively to contain the virus are overreacting? What if the basis for those judgments is wrong or even illegitimate? What if it's a reflexive distrust in science? What if it's just a desire to generate enough activity in the economy to help with re-election? And, viewed that way, which is really, I hate to say it, but really what I see is happening, it all starts to look very different, this federalism question. And if you look at the way federal power is actually being exercised now, or at least the way it's being threatened, the spending power to withhold federal funding to states is being used as a cudgel against governors who are trying to control serious outbreaks of the virus through aggressive exercises of the police power, as Michele described. And if Republicans now had control of the House as well as the Senate and the presidency, one can only imagine the kinds of legislation they would be enacting to limit the ability of states to act aggressively in their own sphere, on the theory, of course, that they were protecting and promoting interstate commerce. And then look what the Department of Justice is doing. It's running around the country filing these statements of interest in district court cases in support of, for example, business owners who are claiming that their constitutional rights to liberty are being violated as a result of business closure orders. They've even gone so far as to file in cases in which the only issue is an issue of state law, and they've gone into court and said, well, as we read state law, the governor didn't have the obligation, didn't have the authority under state law to enact these aggressive lockdown orders. I mean, it's quite remarkable when you think about it, that the federal government would be going into court and saying such things. And so as I said when I started, the federalism question here to me, like every important federalism question, comes down to a question of trust and balance. You could be opportunistic. You could say, you could argue against, you could argue for robust national power if you think it's being exercised effectively. And you could argue for robust protection of the state police power if you think that the national power is being exercised illegitimately or incorrectly. But if you want to be principled, I think you have to choose. And, if you want to have an opportunity to experience the good that the robust exercise of federal power can accomplish, then you've got to take the risk of going through what we're going through now and seeing what I at least think is the misuse. But you could adopt the other perspective. You could decide that you're more worried about over time about the kind of abuses of federal power, at least as I see them, that are occurring now, and that you would be willing to sacrifice some measure of the good that the federal government can do in order to avoid the kinds of consequences that we're now experiencing. So that I think, to me at least, is a way I frame this discussion that we're having today.
Thank you very much, Don. I think that's a really helpful way to frame it, and I imagine that will spur many questions in the Q&A segment. I'm particularly glad. I was going to post a picture of an elephant in a room until you actually got to the second part of your remarks, because I think you addressed the elephant in the room, which is the ideological component that's almost inherent, always inherent, in federal exercises of power. And so that often raises the question, as you put it, is federalism simply a cloak for ideological preference, or is there some doctrinal way through this? We're not going to bog down too much on that, although it made me remember fondly the first term of President Michael Dukakis. I'm old enough to remember the Dukakis administration and the commitment to competence and technocratic precision. Michele, let's turn it back to you at this point. And I understand you may have a PowerPoint slide, which I'm going to cue Cindy to get ready to put up. Let's focus more now on how, more specifically, the structure of U.S. federalism has in fact affected the U.S. response to COVID-19 to date. And also maybe you can discuss a little bit about how federalism is playing out as some states have shifted now into what some are calling the mode of reopening, although it seems temporary or tacit reopening, sadly, in many of those states.
Yeah, well, I couldn't agree more with both Bessie and Don's take, which is that in this context, the states have stepped up to lead, and that should be Plan B in a pandemic. It should not be Plan A. That public health, placing the primary responsibility for public health in states makes sense when it is a state or local problem, but not in a pandemic. And in this case, it has had real costs. So we've talked about some of the political controversy that surrounds it, but let me just get very concrete about the health costs of that. Because of the laconic response, first at the federal level and then at the state level, we experienced significant delays in getting in place the community mitigation measures. And by that, I mean shelter at home, business closures, bans on gatherings that have been critical to flattening the curve. And Cindy, if you could just put up the first slide with the US maps. The point I want to make here is that these delays have been only slight, in terms of the lifetime of this epidemic, but they've had huge human costs. So what you see here is a map of the US in terms of when states got their initial community mitigation orders in place. The dark orange are states that implemented those orders statewide. The hatched states just had them in place, in some cities and counties. And you see here the unfolding of these orders just over a 4-week period in March. When my area in Santa Clara County, California, led the initiation of these orders in mid-March, there were just over 4,000 cases nationwide, and they were really seen as proactive on one view and alarmist in another view. Just a week later, on March 23rd, the number of cases nationally had increased tenfold, and still only 9 states had followed the lead of the Bay Area health officers. A week later, March 26th, the reported caseload nationally had doubled. And keep in mind, this is in a time where we had inadequate testing, so the real numbers were far higher and spreading far faster. And yet only less than half the states had gotten on board by that point. Another week later, again, a doubling of the national caseload, and still 20 states had not taken steps to implement even partial orders within the state. The human costs of this even slight delay have really been staggering. There was one study that estimated that had this same pattern unfolded in just the same way 2 weeks earlier, we would have averted 83% of the deaths in the United States due to COVID-19. That is stunning. And that says nothing of what we might have been able to achieve had this entry of public health orders proceeded uniformly as well as early, so that we didn't have trailing states. So these are born of ideological differences, they're born of value differences, but we shouldn't and probably don't have differences of opinion about the importance of life-saving. And I think people underestimated what they were going to pay in order to be able to preserve state control in pressing other values. For the last month or so, we've really seen this pattern here playing out in reverse. As states have moved to reopen their economies, we again have the same problem of uneven taking of steps with the sort of last in, first out dynamic. We have seen cases massively rebound, followed by hospitalizations a week or two later. We will, within the next 1 to 2 weeks, see a similar pattern playing out with death. Both hospitalizations and deaths are lagging indicators, about 1 to 2 weeks each. And here's just one example, Cindy, if you would put up the next slide, of how pulling out early can have a very dramatic effect. These are data from Texas, compiled by Johns Hopkins University. What you see here with the orange vertical lines are dates where the state began putting in its various community mitigation orders. In green, you see efforts to remove those orders now statewide, and then in the blue, a return to thinking about putting some of those orders back in on a county by county basis. And the story here is pretty clear. You don't need a controlled study to understand what's going on here. As soon as those measures were lifted, cases began to skyrocket. And we all know that this is a story that is playing out in multiple states around the country here. So again, we can really prize individual liberty and state liberty to go their own way. But it becomes a much more difficult story when you have data like this and then consider that there are very few travel restrictions in place across the states. And those that are in place are enforced in a very uneven way. So one state's decision to go this path is going to have an effect on folks in other states.
Thank you, Michele. That was extremely interesting and, if I may say, demoralizing. But what are we going to do? Bessie, let's turn to you again. What do you think, from your experience in the state government, what do you think the various levels of government should be doing? And I wonder if you could also talk a little bit about some of the litigation that has actually been challenging aspects of states' responses. Do you see any evolving patterns or how this balance is being struck in terms of the calibration of federalism?
Well, I'll start with the litigation part of your question first. Obviously, the states, when they act, are limited by both federal and state law, and in particular by both federal and state constitutions. And we here in Massachusetts, I think like many states, have indeed seen and are continuing to litigate cases that, for example, challenge the temporary closing of gun shops under the Second Amendment, challenge the moratorium we have here on evictions on state law and constitutional grounds, and challenge our governor's orders overall as exceeding his emergency powers under state law. But precisely because, as we've all been discussing, the response has been almost entirely at the state level, I'm not sure that I see much of a long-term impact for federalism jurisprudence. I do think it's interesting to imagine what kind of litigation and hard constitutional questions might have ensued if the federal government had had a far more robust response. I expect that depending on the measures, we could have seen some interesting questions about the limitations of Congress's powers under, for example, the Commerce Clause and the Spending Clause and the 10th Amendment and so forth. But we haven't seen those questions simply because there hasn't been much of, there hasn't been much intrusion by the federal government, frankly, to an unfortunate extent. into this health and welfare realm. In terms of what should be done, I'm not an expert in public health, and I would defer to Michele on an overview of what would be better to do. But in terms of thinking through the impact on federalism, to me, it doesn't seem as though there's any sort of grave risk to the principles of federalism here in the future, and in a potentially, hopefully, more robust and effective pandemic response. We have already seen in action, and Michele outlined many of them, the state's plenary powers to protect health and welfare of their residents. And the federal government already has a host of tools at its disposal. So it's been more an issue, as we've all been discussing, of a failure to make use of those existing tools. I think one really important and interesting one is the Defense Production Act. Seems like it was tailor-made for the kinds of PPE needs that we've seen, as well as other healthcare-related resources. As many of you may know, when the national defense so requires, the Defense Production Act grants the President of the United States the authority to require companies to fulfill government contracts for scarce resources and to allocate and prevent hoarding of those resources. And the act contains no exception for orders by the states. Speaking personally, just for myself and not my office, to my mind, increasing production of and allocating scarce resources is an entirely appropriate and constitutional use of Congress's powers to regulate interstate commerce in a time of national crisis under our existing federal structure, to increase the supply of these resources and prevent the kind of unhelpful bidding wars Don mentioned. And of course, there are other federal tools as well that I think portend no threat to federalism or our structure. The CDC's existing authority and ability to collect data and disseminate it, and guidance, and Congress's spending powers to fund a host of efforts to be undertaken at the state level, like contact tracing and PPE acquisition and funding to ensure that people can remain at home and so on. So in other words, I'm not terribly concerned about principles of federalism per se when I think about what the states should be doing, and states and the federal government should be doing. And it's more concerned about failures of execution at both levels.
Thank you very much. I imagine we'll be able to follow up. I hope we'll be able to follow up from other panelists about some of the specific applications of that. Don, let me turn it back to you now. I can't really let you go without talking about what may have been the most relevant case that you were involved with, although it obviously involved a lot of different issues, and that was the so-called Obamacare, the Affordable Care Act challenge, NFIB versus Sebelius, which was decided in 2012. I have to say, many people thought it was a healthcare case at the time. It turned out to be a tax case. That was a victory for your strategy in some ways. But leaving aside the particulars, what, if anything, do you think that case and its progeny might illuminate now about the federalism issues that are arising in the present crisis?
Yeah, Dan, I think about this a lot, actually. I'm involved now in litigating on behalf of the House of Representatives, defending the Affordable Care Act and this current challenge that's in front of the Supreme Court. And it's, I've thought many times, well, what if the NFIB case had come to the Supreme Court in a situation like the one we face now as a country? You remember in the NFIB case, there were basically two constitutional rulings of consequence there. The first was that the commerce power didn't extend far enough to allow Congress to impose the individual mandate to purchase insurance, although it was, as you said, upheld as a tax, and then that there were limits on the spending power, that to the extent that power was used, withholding or withdrawal of federal funds was used in a manner that was coercive of free policy choice by the state, that violated the 10th Amendment. Both of those issues, I think, could be in play now. On one hand, or not now so much as the first issue, not now so much as, but if there is a new administration that does seek a more robust response, on the one hand, I think, well, if NFIB had come up now, it would be so blazingly obvious that there is an enormous, powerful connection between access to healthcare and treatment and the functioning of the national economy that it would be almost impossible to deny that there's a valid Commerce Clause basis for enacting a law like that, because just look at what's happening to the economy as a result of the meltdown of our public health care system. Like, at a minimum, you would think that everybody would be able to see at that point that that law was necessary and proper to the regulation of interstate commerce. But putting that aside, we didn't get that ruling, obviously, in NFIB. We got the opposite ruling, which was that Congress lacked the commerce power. And what it lacked the commerce power to do, according to a majority of the court, was to regulate inactivity or order people to undertake commercial activity that they weren't undertaking. And now I understand that can be read in a cabined way, and one would hope that it would be, and one would hope that if there were legislation enacted, more robust legislation enacted of the kind that Bessie and Michele have talked about in a future administration, that that NFIB's Commerce Clause ruling would be kept confined to that situation of just regulating pure inactivity. But if you think even about the use of the Defense Production Act here, if you're going to tell companies that they can no longer make the cars that they want to make, and they instead have to make some other product that they didn't make and had no interest in making, well, I'm sure some enterprising lawyer is going to say, well, that's compelling commerce, in much the same way that commerce was being allegedly compelled by the individual mandate in the Affordable Care Act. You'd be, and then similarly, if there were any effort to enforce national standards with respect to restricting travel or with respect to stay-at-home kinds of orders, on the theory that there are the kinds of spillover effects and collective action problems I discussed at the outset, you can be sure in a nanosecond that there would be a Commerce Clause challenge to that. And you would have not only the kinds of problems I just talked about, but also you would go back all the way to the Lopez and Morrison decisions from the Rehnquist Court and say, well, as we've discussed, and as is the case, that the regulation of public health is at the absolute core of the state's police power, which is a place where the federal government's not supposed to go. That seems worrisome to me. That set of principles in the NFIB cases out there like a loaded weapon, to borrow a phrase from Robert Jackson, that could be pointed at future more robust exercises of federal power to try to deal with the pandemic. Now, hopefully people would be sensible enough to realize how crazy that would be when you're trying to deal with a national emergency. But that wasn't the reaction of the Supreme Court in the early part of the 1930s in response to New Deal measures. Now, this is, of course, even more intense, given that we're talking about the health of the populace. But still, you need to worry about it. On the other hand, the provision of the law of the decision that I thought of at the time as more of the loaded weapon, which was the spending clause part of the decision, saying that there were these coercion limits on the federal government's ability to attach conditions to the spending power. Maybe that becomes a protection for the states that want to exercise their authority in a more robust way to protect their citizens. So, obviously a lot depends on how events unfold over the next 6, 12, 18 months, but we could see NFIB, I think, coming back into the picture in a very profound way during that time.
Thank you. I see we have about 15 minutes before the time when I wanted to open it up for Q&A. And I do think it's important. We have a lot of people attending and there may be a lot of questions. But why don't we just go around one more time and let me give each panelist, maybe you could do it with a hand raise and we can go around. Is there anything that you'd like to say in response to what anybody else said? Or is there anything that you would like to say that we didn't get to cover that you think is a really important component of this question? I could offer a kind of final framing question, which is basically, what are the lessons that we've learned from COVID-19 in terms of planning for the next pandemic while preserving what you think are the best principles of federalism, if you think there are meaningful principles of federalism. I mean, if you really think that federalism is a cover story for policy, you know, then lots of people feel that way. But let me just open it up, and if anybody would like to just sort of weigh in. It's unfortunate if we were physically present with each other, this would be a little bit easier, but Michele, yeah, please.
I actually have a question I would love to ask Bessie. You know, one thing that's very characteristic, as you've talked about already, of this pandemic is that anytime a state does try to do something, they're immediately slapped with litigation. And Don, you talked about the potential for that to occur had there been more vigorous federal action. How are states thinking about their obligations to boldly go forward, notwithstanding the fact that they know they're going to be tied up in litigation for anything that they do? And do you think that has chilled action in some of the states?
Can you?
I can't speak to the particulars of conversations that we've had with our clients, obviously. I think that our governor in his public statements has been very clear and very consistent that the response in Massachusetts, at least, is going to be driven by the data and driven by, you know, what, you know, the officials charged with all of these public health responsibilities are saying is the right thing to do. And, you know, certainly it's taken up quite a lot of resources in my office, in the Attorney General's office, fighting these lawsuits. But, you know, I think that's not necessarily inappropriate or unexpected. You know, there have been some pretty dramatic changes that we've all absorbed and that have affected different people differently. And, you know, you think of people who are in prison and terrified for their lives. You think of business owners whose entire livelihood comes from operating their business, and then they're told they have to close the door, and they live in a rural area where there are no cases. You know, I don't think it's crazy that there are people with really strong grievances against some of these orders. So, and, you know, as I said earlier, we do have constitutional limitations. So I am sort of proud of our office's work combating these lawsuits, but that's not to say that I don't think that they're, you know, that it's wrong that they should exist. And I'm hopeful that across the country, healthcare policy and public health policy is not being driven by some sort of litigation fear, but instead is being, you know, driven by the best principles of public health protection. You know, I'm sure that to some extent, the fact of constitutional limitations does rightly serve as some sort of drag on overreach by state governments. And if there were a robust federal response, would also serve as a corrective on potential overreach. So I'm not. Let's just say, from my experience, I am not going to come out of this with a concern that, at least in Massachusetts, our response was unduly hampered by concerns about litigation that are unwarranted. I wanted to hear from you, Michele. I was hoping you were raising your hand to give a more interesting and real answer to Dan's question to me about what the states and federal government should be doing, because you know, that's beyond. We just sit here trying to defend what our client agencies are doing, but we don't have a big role in sort of determining at the Attorney General's office, you know, exactly what, you know, the Department of Public Health and so forth and the governor are devising. So I'd really be interested to know what you think we should be doing.
Yeah, well, I think at the state level, you know, the playbook is out there. We know what the major measures are that are at state's disposal here. And we actually have a lot of evidence already about how well each has worked. The research response to this pandemic, I think, has been one of the bright spots. That virtually every academic in any space remotely adjacent to health has immediately pivoted to trying to help policymakers understand the effects of what they're doing. So we know a lot about those measures now, which ones work, how you do it. So continuing to sort of dial back up those measures And I say dial up very, very deliberately, because this is not something that flips on and off, as you know. It is a series of measures that can be calibrated to a set of trigger points in terms of what's going on with the epidemic. So states set out those frameworks. Now they kind of have to stick to them as they go in reverse back up a series of trigger points. The other thing that's been more of a puzzle to me, though, is the extent to which some states have delegated decision-making authority down to counties, cities, school districts, and even individual schools to be making decisions about public health that require enormous resources and technical know-how to do well. Just in my own area, for example, each school has its own reopening committee trying to figure out what public health measures to put in place and how to reopen schools. That seems crazy. So I think there is a need for more leadership at the state level around how to reopen schools and businesses safely, not just a set of bullet point guidelines, but actual leadership in saying this is how experts say it has to be done. At the national level, there is, of course, an enormous range of things that could be done, most of which won't be done, given who is in control. But I think it's important for people to know that although the response to this pandemic has become heavily polarized around ideological lines, there is a playbook for pandemic response that was crafted and refined over a series of presidential administrations, both Democrat and Republican, that is sitting there waiting to be picked up and used. It is incredibly detailed. The latest iteration is from the Obama administration, but there was an article in The Atlantic by James Fallows this week discussing an earlier version that emanated from the Bush administration, and that is chock full of sensible, evidence-based steps that can still be deployed now to try to mitigate the damage that has been done by federal inaction. I think the most immediate steps that could be taken now and that possibly are feasible in this administration are to let CDC resume leadership of the public health response. You know, it was encouraging that we heard from Ann Schuchat this week, but we have not had any evidence of leadership, and that is extraordinary and unprecedented. The US should re-enter the WHO so that pandemic response can be globally led. You know, we've been talking about the need for national versus state leadership, but of course, the response to this should be global. Because we're all affected, as we have tasted so bitterly, by what other countries do or don't do. And then the third is to immediately reverse the position of shaming and calling out governors and health officers who insist on maintaining or reinstituting necessary community mitigation measures. The White House should instead be convening those state and local leaders to come up with coordinated responses to supplement the regional pacts that we have seen in the Northeast among governors there and on the West Coast among our 6 governors, to try to encourage them to come up with a more coordinated regional set of responses that is in lockstep, both because they need the help and because they need the political cover. It's not too late for somebody sensible at the national level to step in and say, you know, we're back up to where our national guidelines say the trigger points point towards reinstituting some of these measures or taking additional steps in the provisioning line or whatever it is, and to give governors the political cover they need in order to do those things.
Michele, may I just also add a question to that, and maybe others will jump in on this. When I began this, I intentionally referred to this pandemic as both insidious and invidious. And my references to people like Orville Faubus were not gratuitous in light of the profound racial disparities that we've seen. I just heard a story this morning that was incredibly disturbing about the Latinx population and the disproportionate effect this is having there. I wonder what that means in terms of federalism, in terms of federal authority. We haven't really grappled with that, but it's obviously a central issue of our time, and I just don't want to leave the discussion without at least confronting it a little bit before we get to the Q&A.
Well, you know, I guess one federalism-related observation is that those dynamics are national, but there are some important state-to-state variations in the extremity of the racial and ethnic disparities in who's affected by the disease. And some of those correlate with earlier state decisions, like who gets access to Medicaid and are we going to accept federal funding for the Medicaid expansion. So I think it calls to mind that state decisions about a basic social safety net, including but not limited to access to health insurance coverage, have profound implications outside those populations. More generally, I think it raises broader questions about our obligations to vulnerable populations, because it must surely be the case that many of these individuals who have fallen sick because they are and have long been essential workers who receive inadequate on-the-job personal protective equipment, and the ability to step out with paid sick leave is absent. They're often living in high-density housing situations. So figuring out how to provide the economic supports to protect people and allow them to protect themselves, their families, and others, I think is really one of the fundamental lessons that comes out of this. You know, there have been other mass global historical events that have provoked a profound reckoning in industrialized democracies about the social safety net. The most famous example being World War II in the United Kingdom and many of the Western European countries, where this experience of shared suffering produced a sense of social solidarity and concrete changes in the social safety net going forward that has insulated the people of those countries to a large extent from future suffering. We have an opportunity now to think about that. And I can only hope that our current political divisions will mend and turn in that direction as our nation begins to heal from the pandemic.
Thank you. I would say I've been reading some very interesting things also about the effect of yellow fever during the drafting of the Constitutional Convention in Philadelphia and during the time of the Alien and Sedition Acts. And there were racial issues then too. Don, I'll give you the last word and then we'll open it up for Q&A. Is there anything you wanted to add?
Yeah, just a brief thought. You know, even if one is really worried about maintaining this appropriate balance between the sphere of federal authority and the sphere of state authority, I guess I would be less worried than, I think there's less cause for worry, I guess I should say, with respect to the kinds of potential robust federal measures that we've been talking about today, because after all, you know, we're in an emergency here. This is a national emergency. And, you know, in our history, the Supreme Court has recognized the power of the federal government to take actions that are directly responsive to true emergency, even if it was pushing at the limits of federal power. And, you know, even in the early part of the New Deal, when the court was striking down New Deal measures right and left, it did in Blaisdell let the state of Minnesota go forward with a law that tried to deal with the fact that nobody could afford to pay their mortgage. And it did allow the federal government to slip the bonds of requiring that federal bonds be paid in gold because it realized that there was going to be an economic collapse if it didn't, you know, further economic collapse if it didn't allow that to happen. And so, you know, I feel like in the present set of circumstances, everybody reasonable is going to understand that the government, and conversely, if you take the steel seizure case where President Truman claimed there was a national emergency, justify that exercise of executive power, the Supreme Court didn't really have a lot of difficulty in saying, well, actually, no, there isn't, and we're not going to let you do this. So I do think the fact that we're in an emergency kind of a situation is one that I would anticipate courts would recognize as requiring for more play in the joints here to allow necessary measures to occur, even if under normal circumstances, courts would be very reluctant to, and including the Supreme Court would be reluctant to embrace the level of federal power that they would apply.
You know, although this emergency could be I hate to say it, but this could be a very long duration. I mean, it's not entirely clear how we mark the end point of this emergency,
true enough.
unless we get very lucky with a vaccine or something.
True enough.
All right, well, let me, I said I wanted to save the maximum amount of time for Q&A. So I'm going to call to the people who are watching this to put your cues forward. We'll attend to the A's. I know people tend to be a little shy sometimes on chat function. It seems to be easier and more spontaneous to just raise your hand when people are looking at you, but please do weigh in. We really value that. It's an important part of what the Rappaport Center is about. And I would say you'd have to pay big money to get to these people to answer your questions under any other circumstances. So you're getting something for free. Lissy, I think you're going to handle that. And just in case I don't get back to you, let me just thank the panelists and thank Julie again and Lissy and Cindy. I think this has really been fantastic. I know I've learned a lot, and I may not get a chance to thank you depending on how it ends. So thank you. Thank you all very much. I truly appreciate it. Lissy, I think I'll turn it over to you now if we have any cues, and if we don't, we can keep talking. But somebody's got to have a question out there.
At the moment, we do not have any cues.
Do people know how to use the, some people don't know how to use the chat function maybe, or the, can you see the participants?
I can see the participants. So if you are looking at the bottom of your screen, you have a button that says chat and another one that says Q&A. Please feel free to use either and ask questions. It is now open for questions. We really welcome them. As Dan said, it is truly part of what the Rappaport Center is all about, is to welcome public discourse, respectful and robust public discourse. So,
Also, Lissy, Cindy, Julie, if you guys have any questions, this would be a good moment to jump in.
okay, so I have two right now. Which factors influence compliance with orders and advisories from state to state?
I'll see if I can take that one. You know, we're still learning about that. There are studies underway that are trying to understand predictors of adherence at the individual level. Right now, what we can see is the extent to which people stopped their movement in states and counties that implemented different orders, but we know less about why that is. We do know there are divisions between states that lead red and those that lead blue. But there is a broader body of scholarship about compliance with the law that I think is useful for maybe theorizing about what some of the things that we may be seeing here. One thing we know from research in a diverse set of areas, but much of it in the criminal law, is that people's perceptions of legitimacy strongly influence their willingness to obey the law. And by legitimacy, I'm talking about a person's recognition that this government official has the moral authority and right to govern in the way that they are. We further know that legitimacy is a function, at least in the public health law space, of a number of other things, including how well the officials have communicated transparently the reasons for their actions, the evidence underlying them, and even more importantly, the extent to which people have trust in that level of government and feel that they are represented in the government. So for example, when I did a survey several years ago about perceptions of legitimacy and willing to adhere to public health measures aimed at preventing non-communicable disease like tobacco use and cancer and obesity, people said the number one predictor of people being willing to do that was feeling that people like me have representation in government and the ability to influence government. So this research, of course, again, it's more suggestive than definitive for COVID-19, but what it suggests to me is that officials who manage to communicate transparently and give the reasons for their orders and clear guidelines around those orders are likely to see greater adherence. And then people that give, over time, the opportunity for people to participate in government and in influencing policy decisions are likely to be more successful down the road. That doesn't mean that we now turn all of this over to a series of town halls. You know, the horse is kind of out of the barn now, but going forward, getting ready for next time, that's something that we can think about.
Michele, I have another question directed at you, perhaps, from Yael Hayer. Sorry if I mispronounce your name. Would you be able to contrast federalism and public health responses in the context of COVID with a neighboring country such as Canada?
So, you know, Canada is also a federal system, and my understanding is that their response has primarily been province-led. Those provinces, of course, are larger than our states, but they also have seen a substantial amount of autonomy and movement across the provinces. I think the main distinction I would point to is at the national level, the leadership has not been perfect, but it has been there. So it looks more like our traditional or expected model of federalism in action, where the more local units of government have substantial authority to act and great experience governing a particular area, but they're supported by a national government that does two important things, if not more. One is some of the scientific and technical work necessary to give the guidance that lets states decide what to do without having to do their own research every time. And the second is the provisioning, providing the practical resources, both monetary and in terms of supplies, equipment, and infrastructure that makes it affordable for states to execute their plans.
Thanks. We have a question from one of our colleagues at BC Law, Hippa Hafiz. What legal challenges might you anticipate to federal vaccination mandates?
Yeah, I was wondering about this one too. This is a big question.
Don, do you want to start?
Yeah, I'll start us off, but we could all probably jump in on it. So the first would seem to me to be under the NFIB decision, there's going to be an argument about whether that's within Congress's commerce power. Because, you know, and this argument actually came up in NFIB, and I think it was your old boss, Bessie Justice Breyer, who raised it at oral argument, that there was a question, you know, under this theory of the commerce power that the challengers were advancing and that the court ultimately adopted. Could the federal government, in the case of a pandemic, order vaccination? Because of course, if you can't order somebody to buy insurance, how can you? Or because you're compelling people to act when they're otherwise just active and not in commerce. How does the commerce power get you the vaccination? Now, I suppose you could argue there's a stronger necessary and proper clause argument there. And in the case of a raging pandemic, that might actually get through to people who it might not otherwise get through to, because they could see that in the absence of the vaccine, the economy may continue to be in this dolorous state that it's in. And so perhaps it would fare better. But I could certainly see that kind of a challenge. And then there'll be a Fifth Amendment substantive due process challenge for sure to a law like that. One could also see religion-based RFRA challenges or free exercise challenges. Under the Religious Freedom Restoration Act, there have already been numerous cases challenging mandatory vaccination laws. And so you can, or state equivalents anyway, of RFRA. So you could see a series of cases of that kind going forward. I would hope that none of them would prevail, at least from my point of view, but you could certainly see there'd be a very real basis for them.
I think that's, by the way, if I may just weigh in, that strikes me as a particular concern where you're talking about a new, relatively untested, rush to market type of vaccine. I hadn't researched this, but I was wondering if challenges were raised during the polio epidemic in the 50s and 60s. I had thought the federal government was subsidizing a lot of that at the time, but actually I don't know. Michele, do you know about that at all?
I don't know whether they subsidize the polio vaccine, but it is the case that the federal government just doesn't really do vaccine mandates. It's overwhelmingly a province of state law. There could conceivably be some vaccination mandates that are limited to federal places, like active duty military servicemen and women, prisons, immigration detention centers. But I think the prospect for a federally imposed COVID vaccine mandate are vanishingly small. As I wrote about last week in the New England Journal of Medicine, I think even at the state level, it's questionable whether we will see mandates. Highly questionable whether they would be imposed and appropriate for children. But were they to be imposed at the state level for adults after a series of criteria for reasonableness and necessity were satisfied, the case law in that area suggests they'd be likely to be upheld if the vaccine was effective.
Anyone else commenting on vaccines? All right, I'm going to go to the next question, which is about contact tracing. Are you hopeful that a robust national federal contact tracing system will be established in the near future? So we know from you, Bessie, that we have contact tracing happening on the state level. Who wants to take the federal?
Well, I guess I can take it. I'm not hopeful. I don't think it will happen. And, you know, this is another area where state and local governments typically do most of the work. And in this case, that really makes sense because this is hyper-local detective work that goes on. What you want to have in place at the national level is a great system of reporting and resourcing. So you want to make sure that the folks on the ground who are doing this work have the money they need to scale up. And then you want to have a robust surveillance system in place, which we have at CDC, so that they can help refine strategies at the state and local level. What's distinctive about this pandemic has been the discussion of digital contact tracing as a supplement to traditional means. So traditionally, contact tracing, as you may know, involves interviewing somebody who's diagnosed with an infectious disease about who they've come into contact with, and then picking up the phone and going out to people's houses and finding those people, notifying them, and taking appropriate measures to ensure that they don't spread it to others. There's been a lot of discussion of the potential for smartphone apps to supplement that by automatically identifying people or phones that other phones have come into contact with, and then either issuing automatic exposure notifications, as has been done in other countries, with requests or orders to self-quarantine, or referring people on to public health authorities. There was an enormous amount of interest, but most of the events or the efforts here in the United States, I think, have sputtered. So I don't expect to see that deployed at scale for this pandemic, even though I think it would be helpful.
Michele, can I ask a follow-up here? What do you envision would be the challenges based on privacy rights where smartphone apps might be implemented?
Yeah, so I've done some writing about this as well, and I also commend folks to a terrific monograph put up by Johns Hopkins University on digital contact tracing that's available for free from Project Muse website. The privacy implications are obviously very significant, and in other countries where these systems have been deployed by the central government, in some cases they've been made mandatory for people. In some cases there have been posting online somewhat detailed demographic information about cases and where they've been. So particularly in a country like ours that is still battered by our experience after September 11th with fairly intrusive laws being put into place out of a sense of emergency and then never pulled back, privacy advocates are pretty concerned about the road that we might be going down with these apps and what the exit strategy is going to be when this pandemic is over. They don't want this to become a new normal. I'm also concerned, though, about the cost of not moving forward with a strategy like that. The mathematical modeling that we have tells us that traditional contact tracing will not work for COVID-19. It simply will not get the reproductive number low enough, and that's because it is infectious in the asymptomatic period and people can't remember who they came into contact with. It's also because it's so casually infectious. So again, we can't just interview and figure out everybody that everyone came within 6 feet of for the last week. So we need a digital supplement if it's going to be effective. And then the question is, how do you design it to be privacy protecting? And in this report from Johns Hopkins and other places, the technologists have put forth a number of features that can help minimize privacy intrusions to the least amount of information necessary for the least amount of time.
Thank you. Okay. Other than requiring citizens of other states to quarantine, what can states like Massachusetts with decreasing numbers do to protect themselves from states that are not, in fact, sufficiently addressing the problem? Is there any possible action to be taken when one state or one state's governors inaction endangers the citizens of a different state? Bessie, do you want me to send?
Sure, I can, I think we've seen there are some measures already being taken. So here in Massachusetts, my current understanding is, and Julie can correct me if I'm wrong, or any of the other residents of Massachusetts on the panel, I believe what we have here in Massachusetts now is guidance from the governor requesting a 14-day quarantine of folks from a whole host of states. And I think that actually just today, or maybe yesterday, the governor adjusted those to account for changes in some nearby New England states, so that there's no longer a requested 14-day quarantine for folks from nearby states that have, like Massachusetts, succeeded in tamping down the epidemic considerably. My understanding is, and I'm vague on the particulars, but that there are other states like Connecticut and New York, I think, or certainly New Jersey, that have put in more stringent absolute requirements of quarantine on threat of fines and so forth from other states. And because we, to my knowledge, have not seen litigation in Massachusetts, because I don't think we have such an absolute requirement, I'm not familiar whether those states have seen litigation. I can well imagine that there could be such litigation. As many of you may know, the Supreme Court has at times recognized a constitutional right to travel, and the states and their, the Dormant Commerce Clause does preclude the states from erecting unreasonable, well, it's complicated, but erecting unreasonable barriers to interstate commerce, and blocking everyone from coming into your state from every other state is a rather considerable roadblock in the field of interstate commerce, it must be said. So I'm not familiar with whether there's been any litigation about that, but I could imagine that there could be.
I think.
So anyway, that's the tool that's most obvious, is literally requiring people to quarantine when they come into the state. I'm not sure at the state level what other measures could be done. I do think that there are obvious things that could be done at the federal level. It seems to me, from a fairly ignorant perspective, particularly having to do with air travel, and to the extent that the federal government were to use its regulatory powers over airlines. I assume that there could be follow-on effects for controlling spread from states that have not controlled the pandemic. But I would defer to Michele if she is aware of sort of the full panoply of potential federal measures.
Just to follow up on that quickly, I think there was a case, or is a case, in Hawaii about quarantine type restrictions in Hawaii, and the other reason I know about it is that it's a case in which the federal government filed a statement of interest suggesting that those kinds of restrictions might be unconstitutional because of the burden on the right to travel.
Don,
Yeah, there are two other.
During the Ebola moments of the Obama administration, I seem to remember New Jersey. It's vague in my mind, but I thought there were legal challenges then too.
Well, the difference is that those are personal quarantine orders that apply to one or a small number of people, as opposed to mass orders, which is what we're talking about now. There are two other live cases involving states' travel restrictions that I know of. There's one in Kentucky and one in Maine, and they've both only been to the district court and only on a motion for preliminary injunction. And perhaps unsurprisingly, the judges in those states had different conclusions about whether the travel restrictions were justified. What we do know is that in both cases, the courts found it appropriate to apply strict scrutiny. So going forward, it would be very important for states to demonstrate there's nothing else they could have done that would have been as effective as the travel restrictions. So, back to the question of what else they could have done, the only other thing that comes to mind for me is to shut down venues that draw out-of-state tourists. As we've seen in California, for example, with Disneyland deciding not to reopen, whereas Disney World in Florida has, there are things that you can do to stem the tide of tourists into the state. And then there are, I think it will ultimately come down to citizens defending themselves from visitors by being willing to wear masks, hand wash, and maintain social distance.
So I have a final question here. How do you balance the consequences of health regulations to prevent deaths or illnesses with consequences to individuals' lives, jobs, and businesses? That the question is on extent of regulations permitted constitutionally.
Bessie, do you want to talk about what the thinking has been within the states?
Well, I was going to say I could offer one comment on the question, which is an excellent question. I think, and Michelle alluded to this with respect to the right to travel cases, it's actually quite context specific depending on what the specific challenge is. So she referenced that strict scrutiny had been applied in that case, which means that the state has to show that it has a compelling government interest and that its means of pursuing that was the least restrictive means. Then there could be challenges, for example, based on a claim that one's property has been taken, right? If your business is completely shut down. And there's a threshold question that the person who's the plaintiff has to overcome before you even get potentially to the broader balancing, which is, was there really a property right that was essentially extinguished as a result? So a lot of the state's orders have been somewhat nuanced. You know, you can't open your business to folks coming inside your shop, but you can do curbside or you can do internet deliveries and so forth. So those kinds of half measures, I think, are stronger on that perspective. Then, for example, in our Second Amendment litigation, part of the entire fight was about what is the standard? How do we balance? So this is why this is such a good question. Part of the fight was, if you close a gun shop as part of closing all of retail shops across the Commonwealth, do we have to meet strict scrutiny in order to justify the emergency order, or rather, as we argued, is intermediate scrutiny appropriate insofar as one is applying constitutional scrutiny, which only requires us to demonstrate a legitimate government interest that we are directly furthering through this measure, which is obviously different from having to show that it's the absolute necessary least restrictive means. So in that particular case, in the gun shops case, the court held that strict scrutiny was not required. I think it's a context specific question in terms of the legality of a lawsuit. Obviously, in the context of a lawsuit is a different question than the actual decision makers within the states who are themselves, from a policy perspective, balancing. And I think there, a lot of the things that Michelle was talking about, I think are likely weighing heavily on the minds of decision makers, which is the importance of folks having trust in the legitimacy of these measures and understanding them. And so, they need to balance, to do this balancing, even aside from litigation risk, they need to do this balancing so that people will actually view the measures as reasonable and follow them and not have a huge outcry. And I think it's going to be, I think closing down in many of our states was so obviously the right thing to do, and it felt really dramatic, but it was on some level easy because just like everyone needs to close down. And now I think it's going to be harder, and I think it is harder already, the opening up and the deciding, how do we balance what to open? Do we keep all the bars and restaurants closed so that potentially the schools can open? Or do we want to prioritize, getting our economy going, and that may mean that there's more disease in circulation in the fall, and so maybe schools won't be able to open. And then even more so, when we have already reopened, and then another wave comes around again, and we have to reclose. I think that the getting folks to sort of, when they're going to be asked to be sort of pivot back and forth, and I think, one might question, Michelle would know so much better than I, but one might question whether the big outcry about masks in particular right now might be in part due to the fact that at the beginning of all this, everyone was told, masks, no point, don't worry about it, save them for healthcare providers, they're kind of useless anyway. And then the guidance sort of shifted of, oh wait, you do need masks. And now there's a lot of resistance to that in a lot of quarters. So I think that's going to be, those kinds of balancing questions are really important on multiple levels. Just above all, frankly, to get to forgetting the public to go along with what the government is asking of them.
I think those are terrific observations. I agree with everything Bessie said. I would just add one point, which is that the question to me also raises the question about process. So one of the things that's been hardest about gaining public acceptance to the orders in many states is that they have been implemented by a single person who is not elected and not democratically accountable directly, which is in many cases a county or in some cases a state health officer. And the processes through which the health officers enter these orders really weren't designed to set up a balancing process for different values, except for the value of one person's individual liberty versus the public health. Because always what health officers have been doing have been dealing with specific individuals who have an infectious disease and need to be dealt with. The scale of what they're being asked to do here by entering these mass orders is unprecedented, and it's really putting pressure on those processes. We're also now shifting out of the period where a lot of this stuff can be done through emergency orders because that time limit has expired. So we're shifting now out of emergency into a new normal, a new way of life. And the question for me going forward is, what should the process be in that new normal? How do we re-involve legislatures in a constructive way from a posture in which they're extremely adversarial to health officers right now in many states? And how do we bring in rank and file citizens into ongoing conversations about dialing up or dialing down measures that will save lives, but at an economic and social cost?
Are there any last questions that anyone would like to have answered? Michelle, can I ask you one more myself? You mentioned that you thought it was, I think you used the word crazy, for states to have different regulations as to school reopenings. And I'm wondering about that given the demographics and geographic structures of states where you have urban communities and highly rural communities. Might there be appropriate differences between states choosing how schools reopen?
Well, I think my comment wasn't specifically about variations across states, but rather within states, that states have left these decisions about schools to very hyper-local decision-making. So that, for example, in my own school district, individual committees of teachers and parents are the ones who are deciding how will the kids sit, what will the hygiene protocols be, how will we bring part of the students back to campus and leave part at home. And it's the same at the university level. Every university is going alone. Now, there's some conversation and crosstalk, but why is that being left to such a local set of decisions by people who do not have expertise in arriving at the things that would best balance the urgent psychological needs of children and their physical safety?
I have to say, I also think that has implications for the question I was raising about racial disparities, class disparities, and many other disparities. But that's a conversation for another day. Thank you. Lucy, I think we're out of time. Normally we provide food to panelists. That's going to be tricky here, but if you give us your addresses, we can send you each an enchilada or some Thai food or something. Let me thank you all again. Lucy, did you want to say any last words? I just am so appreciative to the panelists and to the organizers. And again, to Julie, thank you so much.
I also just want to say thank you to the panelists. It was really, really wonderful of all of you to come. And one of the great advantages, frankly, of Zoom and living in the Zoomiverse is that we get to invite people from all over the country. And now people say yes, because it's so much easier to be able to participate from your own homes or space. So thank you so much, all of you. And Julie, thanks for being the inspiration for the program.
Thanks for having us.
Yes, thank you. It was terrific.
Thanks, everyone.
Thank you.
Take care all. Stay well. Dan, thanks so much. Great moderating.